One of our favorite secret weapons for problem solving and negotiating is local real estate attorney Brian Lytle. In this series of Get Smart, Brian shares insights on estates.
Hi, I'm attorney Brian Lytle, and in today's Get Smart segment, we're going to take a look at estates. And before we get into the nuts and bolts, let me just remind you that this is not specific legal advice. Rather, it's a broad overview. When we look at specific items, I need facts and documents. In our area, in the Lismore area, there are three contracts that are used. The RAIN contract that's used on the Virginia Peninsula, the CVR contract that's used in the Richmond area, and the VR Virginia Realtor contract that's used in the Williamsburg area and statewide. Each contract handles things a little bit differently, and in some cases very differently. But in our context, that's not so important today. And those contracts are all fairly drafted for both buyers and sellers, and in that way, your Lismore and Associates agent can use the same contract whether he or she is representing a buyer or a seller. Again, the purpose of this Get Smart segment is to take a look at estates in order to try and help figure out who the seller should be, and there will be other segments that drill down. But if you have any questions, make sure you ask your Lismore and Associates agent for help, and he or she can guide you in the right direction, if not provide the answer. So what we're talking about here are transfers at death. That is, one or more of the owners of the property have passed away, and so the question becomes, all right, well, who's the new owner? Who is the seller? And painting with a broad brush, there are about four basic ways that property can transfer at death. Survivorship. Property can transfer through a will. That's called testate. When someone dies testate, that is, they have a will. Intestate means they have no will. And then there's a new thing really under Virginia law called a transfer on death deed, and I've just used the acronym TODD. So those are the four fundamental ways that property can transfer from someone who has passed away. And so this segment concerns itself with the broad identification of how the property is transferring. And so once we've narrowed it, there are other Get Smart segments that address those particular topics. So back to our four. The first is survivorship. So when the then buyers, now sellers, took title, their deed may well have had a provision that says with right of survivorship. A married couple can take title as tenants by the entirety with the right of survivorship, and that's a special form of title in Virginia for a married couple. And if it's present and one has passed away, then title is automatically, by operation of law, vested in the survivor. There's also joint tenants with right of survivorship. That is where the buyers are not married, but it specifically has those words in the deed, and it works the same way. That is, by operation of law, title is transferred to the survivor. I want to point out here that if there's a will, the will is irrelevant. Brian and Brenda may have taken title with right of survivorship, but Brian's will says that Brian gives the property to George. George isn't getting that property because the deed had a right of survivorship in favor of Brenda. So under those circumstances, the will is irrelevant. And if you are a seller who is selling the property where one of the co-owners has passed away and there's right of survivorship, then all you're going to need to do is prove death. A death certificate is sufficient. The survivor or the survivors are the sellers, and they sign. Similarly, I mentioned earlier transfer on death deed. Well, that's a relatively new thing in Virginia, and if a transfer on death deed has been recorded, then what it does is it names a beneficiary for real estate. Just like you might have a beneficiary designation on life insurance, you know that when the person dies, the money is paid by the insurance company to the named beneficiary of the policy. Similarly, in Virginia, you can now do that with real estate, and it's via something called a transfer on death deed. So if that's done, and they're still relatively rare, but if that was done and that deed is recorded, then it will name the beneficiary of the property or beneficiaries, and those beneficiaries are now the owners and they're now the sellers. What will need to happen in order to get closed is that the beneficiaries of the property under the transfer on death deed will need to prove the death. Again, that's by a death certificate, and then they are the sellers of the property and will sign both the contract and ultimately the deed. Next, so again, back to our 4 ways. We talked about survivorship, we talked about a transfer on death deed, and if neither of those apply, then we're looking at, is there a will or is there no will? And it's a broad, painting with a broad brush, it's really that simple. But it gets complicated from there. And so at this point, what I want to do is refer you to the Get Smart segments on executors and heirs. You basically, if it's a will, then you're looking at the executors segment. If it's heirs, that is no will, then you're looking at the Get Smart segment on heirs. Thanks and have a great day.
Be sure to subscribe and turn on notifications for our next installment of Get Smart with Brian Lytle.